Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're in session number six, if you can believe that, of our new series entitled The QME Forensic Super Sleuth. And I have a fascinating program for you today, one that I'm certain will be of use to you with your very next face-to-face evaluation, because today, in today's discussion, we're going to talk about the many things that examinees don't tell us in our face-to-face interview and also in our physical examination with our examinees. And before we get into the topic of today's discussion, let's just review the philosophy of this program and where we've come from so far in our first 5 sessions. So the philosophy of this program, the QME Forensic Super Sleuth, has to do with the obligation that we have as qualified medical evaluators to resolve disputed issues in the workers' compensation system. And resolving disputed issues would be an easy task. It would be an easy matter. It would be a slam dunk if we had all the information that we require in formulating our opinions and conclusions and in conducting our medical decision making. However, it seems that for a variety of reasons, parties fail to provide us with the information which, if we had, our jobs would be so much easier. So as a result, we're left to ourselves to determine and discover the information that we need, that we rely upon in providing our opinions and conclusions, such that those opinions and conclusions would qualify as substantial medical evidence and would actually be relied upon by the parties in resolving disputed issues. So we suggested that there are 3 parties that withhold or fail to provide us with the necessary information that we require. Number 1 is the parties in advance of the face-to-face evaluation, the parties being the claims administrator, any applicant attorney, and any defense attorney fail to provide us information about the issues that are driving the need for our evaluation, which if we had, we could more easily know what is our role during the evaluation, and we would know exactly how to comport our procedures during the interview and the face-to-face examination with the injured worker. So the party is number 1. Number 2, at the face-to-face evaluation, examinees sometimes fail to provide us, or they withhold from us, information necessary for us to provide accurate opinions and conclusions in our report. And we started our last session talking about how to obtain truthful and accurate history from the examinee, and we're going to continue with that in today's discussion. And then the third parties that withhold information from us are the attorneys, the applicant attorneys and defense attorneys, when it comes time for us to become deposed, to be deposed, or to attend deposition. Prior to the deposition, if the parties were to inform us as to the questions and the issues that they're going to explore with us in the hot boiler room of the deposition, well, then depositions would be much more enjoyable, and we could certainly feel a lot better about ourselves coming out of deposition if we knew what were the issues driving the need for the deposition. So we're in our 6th session today, and to set the stage for today's discussion, remember that in our last 2 sessions we began talking about post-employment claims for industrial injury. Many times, examinees present to us for an evaluation when the disputed issue has to do with the presence or absence of an industrial injury for a claim that was filed after the employee has separated his relationship with the employer. These are the so-called post-employment claims. Now, rarely are we ever told that the evaluation is involving a post-employment filing of a claim for industrial injury. We have to figure this out for ourselves. And it's important that we figure this out in advance of the face-to-face evaluation, because this particular species of claim, which is rampant in California, has a unique and specific handling. These are cases that come to us under Labor Code 4060 for the compensability exam, and these are radically different types of evaluations compared to the evaluations that come to us under Labor Code 4061 and 4062, which involve issues other than the compensability of the claim. So these issues, these cases require a very specific handling, and if you're not aware of the circumstance of the post-employment filing of the claim prior to meeting the examinee face-to-face, then your evaluation is not targeted to the issue in dispute. So we talked about post-employment claims and how the law generally bars post-employment filing of claims for industrial injury with 4 major exceptions. And we began talking about the 4 exceptions to the post-termination defense in our 3rd and 4th sessions. And in our last session, we talked about the remaining 2 exceptions, which have to do with the dates of injury for specific injuries and the dates of injury for cumulative trauma types of injuries that are filed post-employment. So in today's discussion, I want to talk to you about how to obtain an accurate history from the examinee so that you can resolve the issue as to the presence or the absence of an industrial injury, whether that be a specific injury or a cumulative trauma injury for these claims that are filed post-employment. And I want to talk to you about how to obtain accurate and truthful facts from the examinee that will allow you to arrive at the proper conclusion, either for industrial injury or against industrial injury. And you can feel confident that you've made the correct decision 100% of the time. And it all pivots on obtaining accurate history from the examinee. So with that as our introduction to today's discussion, let's begin session number 6 of our new series. And today we're talking about truthful and accurate history in the face-to-face interview. Okay, so to review, under Labor Code 3600, the law generally bars, prohibits, blocks, and prevents the filing of claims for industrial injury post-employment. It blocks the post-employment filing of claims for industrial injury with 4 exceptions, and we'll review those 4 exceptions here in just a minute. Now, it's under these 4 exceptions, and really under only 2 of the 4 exceptions, that cases are going to come to us for our opinion as to yes, an industrial injury exists, or no, an industrial injury does not exist. And these cases come to us under Labor Code 4060. And it's under 2 of the exceptions that we're going to be seeing these cases that otherwise, by law, are barred. Okay? And it's these 2 exceptions that create a flood of these particular species of cases in the state of California. By some estimates, there are as many as 30,000 of these claims being filed per month, every month, in the state of California. And the reason is because of these 2 loopholes or these 2 allowances in the law that create an opportunity for claims to be filed post-employment. And we'll talk about those, and we're going to talk about your role as the qualified medical evaluator in coming to a final opinion and conclusion as to AOE COE, industrial causation, which is our job in these particular cases. So we're going to talk about your role in discussing industrial causation. And it has to do, coming up with the proper opinion and conclusion has to do with the subtle distinctions between AOE and COE. Now remember, COE stands for occurring in the course of employment, and these are decisions. The COE decisions are determined by the trier of fact, which is the judge. The COE issues have to do with factual issues, the factual actual occurrence of an industrial injury. And many times in these cases, the factual, actual occurrence or non-occurrence of an industrial injury is a question of fact that cannot be determined by the qualified medical evaluator. It can only be determined by the judge. Now, in coming up with an opinion on COE, the trier of fact, the judge, does rely on the AOE opinion of us as the medical evaluators. And AOE stands for arising out of employment, and we'll talk about your role in providing an AOE opinion in these cases. And I'll just let the cat out of the bag a little bit. And that is, in my opinion and in my experience, it sometimes is very, very difficult to separate AOE, COE. They are at times inseparable, or perhaps I should use a phrase from the workers' compensation system and say that AOE and COE are many times inextricably intertwined and cannot reasonably be separated from each other in arriving at an opinion on industrial causation or not. And we'll elaborate on that here in just a couple minutes. But just to review, the exceptions to Labor Code 3600 that allow post-employment filing of claims are: number one, that the employer was provided notice of the injury prior to the separation of the employee from the employer. Now, it would seem that this is a very stiff and tight requirement, because one of the requirements to qualify for notice, it says the employer is provided notice. One of the criteria to qualify for notice is that the employee must provide the employer written notice of the injury. So that would seem to be a very strict, stringent, and constrained criteria that is either provided to the employer or not. That's a matter of fact. That's an objective fact. Did the employee provide notice or not? If the employee cannot prove that he provided notice to the employer, then this section is not satisfied and the claim dies in its track due to the post-termination defense. Now, the loophole to this section of the law that creates an opportunity for many claims to be filed post-employment is that what qualifies as notice becomes softened under Labor Code 5402, whereas Labor Code 5400 requires a written notice from the employee. Labor Code 5402 softens the requirement for notice and basically creates an opportunity for almost anything to be perceived as the employee giving the employer notice of an injury. So Labor Code 5402 states that if the employer has knowledge of the injury, and who can prove that, right? It's very subjective. Knowledge of the injury from any source qualifies or is equivalent to a written notice. So in this particular loophole, employees or examinees will always tell you in the history, and they'll also get it into the written history in the medical records, that they told their employer, that they told their supervisor, that they told the manager, that they told someone in human resources, that they told their coworker to tell the supervisor, that they had their son call the supervisor. They will say things like, I left a note on my supervisor's desk. And they'll use a myriad of examples as to how they provided the employer knowledge of the injury sufficient to allow the employer opportunity to investigate the facts, which qualifies as providing notice and satisfying this section, which then allows the claim to move forward. So this particular exception to Labor Code 3600 is going to create many opportunities for you to see these examinees face to face because of the great liberality of what qualifies as notice. Okay? The second exception, do the employee's medical records contain evidence of the injury? And this has to do with the employee's medical records with their primary care physician or their private physician, which is very difficult to satisfy I've had these types of cases where the employee was able to produce medical record evidence of the injury before the date of separation from their employer, in which case, if this is satisfied, then the claim can move forward. But I'm telling you that this particular exception is going to bring you nowhere near the volume as this particular exception, because the medical record evidence of injury is an objective criteria, whereas the employer provided notice is largely subjective on the basis of the softness of Labor Code 5402, which softens what is otherwise required to qualify as notice being provided to the employee. The third exception, 10C, has to deal with the date of injury of a specific injury claim, which creates a very, very narrow window of time wherein the employee can claim that a specific injury occurred after he was given notice of termination or layoff, after that date, but before the date that he was actually separated or terminated from the employment. So if the employer provides the employee with a notice, say on November 1st, and the date of separation or layoff is December 1st, that's a 30-day window. Well, employees could reasonably suffer industrial injury in that 30-day time period, and if they do, then the claim can move forward. But they cannot claim a specific injury to have occurred prior to November 1st, because that is barred under this particular exception. So you will get examinees under this particular exception to Labor Code 3600, but again, because of the narrow window that's defined by this particular exception, you're not going to see as many cases as you're going to see under exception 10A, because this is a very objective and tight, constrained time frame, whereas the employer provided notice is loose and soft and creates great opportunity for dispute to arise that must then be resolved by us as the qualified medical evaluators. So here, this is the biggie that's going to bring you many, many claims that are claims filed for post-employment, either specific injury or post-employment cumulative trauma injury claims. Okay, and let's talk now about the final exception, which is going to bring you the greatest bulk, probably 8 out of 10 of your next 10 evaluations. And the next exception to Labor Code 3600 that would or could allow the filing of post-employment claims to move forward is Section 10D, which has to do with the date of injury for cumulative trauma injury claims. And I submit to you that this is going to bring you a great, great bulk of cases over the next several years at least, and probably will be increasing over the next several years, and probably has no end in sight, because this is the great loophole that allows these claims to move forward and allows employees who, long after their separation from their former employer, can come back, and I'm talking months, years, multiple years, even decades later, can come back to their prior employer and claim that while they were with the employer, they suffered a cumulative trauma injury or illness. And it has to do with the date of injury being subsequent to the notice of termination or layoff. And the great loophole here has to do with when the employee claims to have obtained knowledge of the cumulative trauma injury. Knowledge, and many times this is completely subjective. This is the great loophole. It's completely subjective. The employee claims that they never gained the knowledge until after they were long gone from their former employer. And how can that be disputed? It's indisputable. So this creates the great opportunity for thousands and thousands and thousands of these claims to be filed every single month. So this, along with exception A in large part and exception B and C in smaller part, this is why you're going to be getting these post-employment claims. It's because of the exceptions. Otherwise, the law generally prevents and bars the filing of industrial injury claims post-employment, except for exceptions, and it's these exceptions that can be exploited to allow these claims to at least come to us for our opinion either for or against industrial causation. So our opinion for or against industrial causation in these exceptional scenarios has to do with our AOE opinion. So let's talk about what the role of the qualified medical evaluator is in providing an accurate AOE determination on these post-employment claims. So these cases come to us under Labor Code 4060 for the compensability evaluation, which requires an opinion from us as the qualified medical evaluator either for or against industrial injury. Now, again, the COE determination is provided by the trier of the fact, the judge, and the judge relies on us as the medical evaluator to provide our opinion on AOE. So as this relates to the exceptions under Labor Code 3600, let's think about these exceptions. Exception A has to do with whether or not the employee provided the employer notice of the injury prior to the date of termination or layoff. This is an issue that's resolved by the trier of fact. This is a COE determination. Exception B has to do with whether the employee's medical records existing prior to the notice of termination or layoff contain evidence of the injury. This is something that is decided and resolved by the trier of fact, not us as qualified medical evaluators, because this is a COE issue. Exception C has to do with the date of injury for specific injury claims. This is resolved by the trier of fact, not us as the qualified medical evaluator. Finally, for the cumulative trauma injury claims, it's the trier of fact that determines whether the date of injury qualifies for exception D. In other words, the date of injury is after the notice of termination or layoff. So these are COE issues. The judge determines whether the examinee qualifies for one of the exceptions under Labor Code 3600, and still we get these evaluations. Why do we get these evaluations for our opinion when the COE issue, the course of employment issue, is resolved not by us, but by the trier of fact? In other words, what is our role as a qualified medical evaluator? What's our role? What are we to do? Well, in my opinion, this is why it's so critical that we understand that we're dealing with post-employment claims in advance of the face-to-face evaluation so that we can understand what our role is. And our role has to do with AOE, and we should limit our discussion in the causation section of our report to AOE and allow the trier of fact to resolve the COE issue, knowing that the trier of fact is going to rely on our AOE determination in coming up with his or her COE determination. Isn't that fascinating? So as the qualified medical evaluator, in resolving the AOE issue, the question becomes, here's the operative question, the question that we're faced with, the question that we have to resolve, the question that the parties are asking us to resolve is it reasonably medically probable that the symptoms that the examinee is relating could have been caused by an industrial injury to have occurred in the way that the examinee stated that it occurred? Let me rephrase that and let me clarify that for you. So examinee comes to us for a compensability evaluation under Labor Code 4060. The occurrence or non-occurrence of the injury is a question of fact. Did it occur? Did it not occur? We don't know. We weren't there. This is resolved by the trier of fact. Our role as the qualified medical evaluator is to give the trier of fact some information about the examinee's condition and about the probability that the examinee's condition, whatever it is, was or was not caused by an industrial injury to have occurred the way that the examinee said that it occurred. So where do we begin with this? Where do we begin? As qualified medical evaluators, it begins with determining the examinee's condition. Examinee comes to us claiming a condition as a result of an industrial injury. Our job is to evaluate the condition and report on the probability that the condition was caused by an industrial exposure to have occurred in the manner that the examinee claimed that it occurred. So issues that we as qualified medical evaluators deal with in coming up with an accurate AOE determination, and this is not a complete list, but first and foremost, it revolves around, does the examinee actually have a bona fide medical condition? The examinee comes in and claims that they suffered a right shoulder injury due to an industrial injury 2 years ago. Our role as a qualified medical evaluator is to determine, does the examinee actually have a bona fide medical condition that rises to the level of an injury of the right shoulder? And some of the issues to consider in determining the probability with which that condition could have been caused by an industrial exposure to have occurred in the manner the way the examinee described it to have occurred has to do with, number one, the concept of reversibility. And this has to do with conditions, painful conditions, reversing themselves when the exposure to the injurious environment is reduced or eliminated or ceased. Okay, and this is very common phenomenon with cumulative trauma injury claims, where examinees will tell you that when they go home on the weekend or when they go away on vacation, their condition seems to get a lot better. But when they come back to work, either the following Monday or after a vacation, the condition quickly worsens itself back to its original bad state. So this is the concept of reversibility. And in cases of cumulative trauma where the employee has been separated from the employer and thereby separated from the injurious environment for weeks, months, years, we would expect some reversibility of the condition, and that will be something to consider in arriving at your AOE determination. Number two, whether or not the examinee has had adequate medical care. So for example, many times these examinees, they come and they tell us about an industrial injury suffered when they were with their former employer weeks, months, and years ago. And in the time in between the injurious exposure years ago and now, they've obtained medical care either on a lien basis under workers' compensation or with their primary care physician, and they've received treatment for this. What benefit has adequate medical care given to the condition? And has the examinee properly and appropriately responded to that medical care? The purpose of medical care is to create an improvement, is to cure or relieve the effects of the condition. And in the absence of any benefit from medical care, that is something that you would need to consider in arriving at your AOE determination. It raises the question as to the necessity of that medical care that was delivered. Number three, and this is not a complete list, has the employee had adequate accommodation at work? Have they been provided, were they provided work restrictions? Were they given total partial disability or total temporary disability? The purpose of work restrictions, partial disability, total temporary disability is to help allow the condition to recover. And an examinee who has been provided with total temporary disability or has been not working for the employer for weeks, months, and years we would expect that that condition would respond to the healing benefit of time and being away from the injurious environment. And so this is just another consideration that you can investigate when providing your AOE determination. Finally, and another consideration is, has the employee obtained a new job following separation from the former employer against whom they're filing a claim for industrial injury post-employment? And I recently had two similar cases. I guess I'll just tell you about one of them, where in the first case, I'll just tell you about this case, involved an attorney who was doing some legal work for a startup company. And this involved desk work and repetitive typing, working with files, etc., desk work. And the attorney separated from the former employer, got a new job with a new employer doing the same type of work, exactly the same. Long days in front of the computer typing, working with files, do administrative paperwork. It was the same type of work. And he was claiming an industrial injury against the former employer, and he was reporting symptoms on the day of the face-to-face evaluation that he attributed to the work with the former employer, when in fact he was doing the same type of work on a daily basis every day since the separation from the former employer up until the time of the face-to-face evaluation. And many times when employees get new employment, their job duties are not substantially different than they were with the former employer, and this may be something that would go into your consideration when it comes to providing your AOE determination. Additional considerations could include the nature of the former job duties and whether or not the former job duties could reasonably result in the condition that the examinee is reporting to you. Are there any outside contributors that could also either contribute or be the direct cause of the complaints described by the examinee? For example, a secretary who does desk and computer work all day reports repetitive and cumulative trauma upper extremity symptoms, including thumb tenosynovitis and elbow lateral epicondylitis. And in the history-taking portion of your interview with the examinee, you learn that the examinee is an avid tennis player, okay? And it seems that the outside activities are far more vigorous than the activities at the job location. Okay. Finally, has the examinee suffered any subsequent injuries after separation from the employer? Subsequent industrial injuries, subsequent non-industrial injuries, subsequent motor vehicle accidents that could be contributing, or that could be the direct cause of the condition that the examinee is reporting to you on the day of the face-to-face evaluation. So all of these things could contribute and could factor into your AOE determination, which again, the AOE determination involves the determination as to whether or not a bona fide medical condition exists that rises to the level of injury, and if so, is it reasonably medically probable? See, this is what the judge is going to rely upon us to answer. Is it reasonably medically probable that the medical condition, the bona fide medical condition, could have been caused by the workplace duties to have occurred in the manner described, the way the examinee described them to have occurred? So it begins with a bona fide medical condition. If you don't find a bona fide medical condition, if you find a normal physical exam, no findings on physical exam, no medical condition, you can easily opine against AOE by finding that there is no medical condition present. If you find a medical condition present, and this is going to be a common occurrence, you will find medical condition, examinees will come to you with the medical condition that they describe. When you find a bona fide medical condition, the presence of a bona fide medical condition does not equate to a opinion for industrial causation. It does not directly contribute to that. The question then becomes, could that medical condition reasonably have been contributed to by the workplace duties as described by the examinee? And that's where your complex medical decision making comes into place. And that's where it's important that you obtain accurate historic facts from the examinee. So let's talk about just how to do just that. So when these examinees come to us for the AOE and COE determination, we're going to be faced with two populations of examinees, and those are examinees number one, who have indeed suffered a bona fide incident of either specific or cumulative trauma injury with their former employer, or number two, those who have not. Those who have not. Now, remember that most of these claims come to us on a denied basis. So on a denied basis, the claims administrator is telling us that the claims administrator does not believe, or the claims administrator has no evidence that the employee has satisfied any of the exceptions under Labor Code 3600 that would otherwise allow this claim to move forward. So the claims administrator's position is that the claimant is not telling the truth about the presence of a bona fide industrial injury. And still these examinees come to us. So the examinee, in our opinion, when it comes time to provide our opinion, we're going to provide an opinion that the examinee is telling the truth, or that the condition or symptoms that the examinee is reporting to us are not the result of an industrial injury as the examinee is alleging. And in order to properly make this very, very difficult determination, it's important that we obtain accurate history on the issues revolving around AOE. We talked about several of those on our last slide. So I want to share with you a couple of concepts that you can use in your history-taking interview with your examinee. And these are some concepts that come from forensic interviewing techniques that are now being applied to insurance claims. And many of you may be familiar with insurance claim investigations and interviews, where, say, for example, you've been in an auto accident and you get a phone call from an investigator at the insurance company, and the investigator at the insurance company takes you through a series of interview questions. And let me tell you that those interview questions and your responses to those interview questions, your verbal responses, the content of your responses, are analyzed for deception by those insurance claims investigators. Well, some of these techniques have application to the work that we do as qualified medical evaluators in providing our AOE determination, and I want to share some of those with you. And what I want to share with you today comes from two studies, one of which is entitled Using the Verifiability of Details as a Test of Deception, and I have that study right here with me, and I'll be citing some references from that study. And the second one is entitled Impression and Information Management, on the strategic self-regulation of innocent and guilty suspects. And for our purposes, it might be phrased, or better titled, on the strategic self-regulation of truthful and untruthful claimants for industrial injury. So let me just share a couple of ideas from these studies that will help us in obtaining accurate historic details from our examinee. Well, according to the first study, Using the Verifiability of Details as a Test of Deception, this study tells us that the default setting in human communication is honesty. Humans default to honesty in communicating interpersonally. Well, in contrast to honesty, the act of lying requires extra mental effort compared to telling the truth. Because a liar, a claimant for industrial injury who did not actually suffer industrial injury, has to try to fabricate or create or construct a convincing lie for an industrial injury. And this requires extra mental effort and creates a different set of challenges for the false claimant compared to the honest claimant. And knowing this and exploiting this extra mental effort can many times expose the false claim for industrial injury, which would allow the proper AOE determination from us as the qualified medical evaluator. And then also the converse is true in those cases where it is evident that the claimant for industrial injury is reporting what is otherwise a bona fide incident of industrial injury. Well, the study tells us that the most reliable differences between truths and lies is manifested in the verbal rather than in the nonverbal behavior. So, in other words, the lies are to be found in the words, and they're not to be found in the body language of the false claimant. According to this study, body language and physical body cues of deception are faint and unreliable, and it's very, very difficult to discern truth tellers from liars on the basis of nonverbal body language cues, but rather we are to focus on the words, on the content of the statements, knowing that the content of the statements of liars compared to truth tellers are going to involve some extra strategy that involves extra mental effort in coming up with a story that is untrue, but that has to be portrayed in convincing fashion to create an honest impression in us as the qualified medical evaluators. So in just knowing that liars are faced with a difficult task that requires extra mental effort to create a false event of industrial injury in a convincing fashion to you as the examiner, just knowing this in advance allows you to the opportunity to exploit this difficulty faced by false claimants to open up a gap between false and true claimants and to accurately provide your opinion on AOE. So you do this by asking the examinee to please describe in as much detail as possible how you develop the symptoms or the medical condition that you ascribe to a cumulative trauma injury with ABC employer. You ask them to provide as much detail as possible. And this is out of a study entitled Using the Verifiability of Details. So it's all about details, and you want to obtain from the examinee as many details as possible. Now, this places liars, false claimants, in a dilemma. It creates a difficult dilemma for them to solve, and this requires tremendous mental energy not required by true claimants. And false claimants are inclined to mention sufficient details to provide a convincing false account, but on the other hand, they try to avoid mentioning those details that can potentially be verified by the interviewer. So as a solution to this dilemma, the need to provide sufficient detail to be convincing, contrasted with mentioning too many details or potentially mentioning the details that could be verified by the interviewer, as a compromise between these two opposite ends of the spectrum, liars will provide many details, but those details will be non-verifiable details that you as the qualified medical evaluator or any other person would have no capacity to be able to verify those details. So when you interview your claimant for industrial injury, you're going to ask them to provide for you as many details as they possibly can while you as the qualified medical evaluator are listening and searching for those details that could potentially be verified, and is found by study is in insurance claims interview settings that examinees who suffered actual industrial injury and who actually qualify for workers' compensation benefits will be able to provide copious details which could potentially be verified by any concerned party. So the first secret to obtaining accurate history from your examinee as to the presence or absence of a bona fide industrial injury has to do with obtaining details regarding the medical condition and regarding the industrial nature of that condition that could be potentially verifiable. And it's found that examinees who actually suffered bona fide incident of industrial injury will provide many, many details that can be verified, whereas false claimants will provide many details, but those details have no way to be verified by either you as the qualified medical evaluator or even any other person. Okay? Now, our second study, Impression and Information Management, on the strategic self-regulation of innocent and guilty subjects, has to do with how our examinees regulate themselves during our face-to-face interview and our physical examination of them. And this study tells us that cues to deception can emerge from liars' strategies to appear honest. So those who are claiming industrial injury, who actually did not suffer industrial injury but who are merely seeking benefits, have to employ strategies to us to appear to be honest and truthful to us and to create a favorable impression upon us. Well, cues to their deception can emerge from the very strategies that they employ in appearing honest that truth tellers don't have to employ at all. And this study tells us that much of social behavior is self-regulated, for the purpose of interpersonal presentation. That is, people aim at coming across as favorable in the eyes of others, especially us as qualified medical evaluators, and therefore they edit and groom their self-presentation to come across the desired way. And sometimes, in an effort to appear to be honest and in an effort to appear favorable to us, the liar gives themselves away by their extra effort expended that is not required by those who are simply telling the truth. So how does this play out in the qualified medical evaluation? Well, examinees who suffered a bona fide incident of industrial injury, in other words, the truth teller's claims of industrial injury are legitimate, whereas liars' claims for industrial injury are not legitimate. Therefore, truth tellers, they have a bona fide incident to report, a bona fide event, a bona fide incident of injury to report, whereas liars do not have a bona fide event to report. So when liars report an industrial injury, the event is not an actual event, but rather is a fabrication from their imagination. So truth tellers who claim industrial injury will not need to fabricate an account to support their claim, as they can draw freely from their self-experience, from the self-experienced event. This says even, it should say event. So truth tellers draw freely from the self-experienced event. They have no need to fabricate an account. But the liar, the false claimant for industrial injury, must engage in information management. A truth teller does not have to manage information. They can simply draw freely from the memory of their event. Whereas false claimants must replace truthful information about their work history with a specious account of an industrial injury, wherein they claim an industrial injury. They create a specious account that is a product of the imagination and is not a product of the memory of the event, which is upon what truth tellers draw when describing their own experience with their own industrial. And so doctors, isn't that fascinating? These are techniques that we can use in the interview of our examinee in order to arrive at an accurate history and an accurate recollection of the facts for industrial injury that allows us as qualified medical evaluators to provide an accurate opinion on AOE in these claims that are filed post-employment. So it's interesting. These cases, they come to us with information that's not provided to us. We're not told that these are post-employment claims. And then in the face-to-face evaluation with the examinees oftentimes don't tell us. They don't tell us information that we could use in coming up with our opinions and conclusions. And so the difficulty on us as qualified medical evaluators is compounded by these parties failing to provide us information that we need. And so that it's incumbent upon us to dig for the information that helps us to resolve the issue in dispute. And in terms of obtaining accurate history from our examinees, these two studies that we reviewed tell us that truth tellers versus liars will portray differences in the history that they provide to us. Truth tellers will simply relate to us what happened with no mental energy expended on creating any type of an account whatsoever. They simply draw upon the recollection of the event as they remember it to have occurred. It seems that truth tellers believe that the world is a just place, that good things happen to good people, and that the truth is simply good enough. In other words, they don't feel compelled to have to manage the information that they provide to us as the decision makers as to the presence of an industrial injury or not. On the other hand, liars will provide a simple and streamlined statement that is generally vague of details. If the false claimant is pushed to provide additional detail, those additional details beyond that which is included in their streamlined statement, they will struggle. And they will resolve the struggle by attempting to provide as many details as they can, but they will default to the type of details that are vague and non-verifiable. The reason that they're non-verifiable details is because that the details of the incident are not based upon an actual event. They're based upon a contrived account of an industrial injury. And so these differences in the communication strategies between true and false claimants for industrial injury quickly can be opened up and exploited with some proper interviewing techniques, which will then allow you as the qualified medical evaluator to arrive at the perfect AOE determination in every single case. So doctors, I hope this helps you. It's a tremendous responsibility being a qualified medical evaluator, and in every single case, the parties rely on us to provide opinions and conclusions that are accurate, that are the most accurate representation of the actual occurrence or non-occurrence of an industrial injury that can possibly be arrived at considering the technology that we have at our disposal. You know, the stakes are so high in these industrial injury claims that the final opinion and conclusion absolutely has to be accurate and correct every single time. And in today's discussion, we talked about some techniques that you can use in your interview of the examinee to help you get it right every single time. Okay, so in our next session, we want to conclude our program talking about what they don't tell us in preparing for depositions. And I'm going to share with you the most common situations and the most common questions that you can expect in your very next deposition so that you can properly prepare for that deposition, and you can come out of that deposition smelling like a rose and feeling confident that you performed perfectly in your very next deposition. So for today, this is Dr. Perry Carpenter. I want to thank you for taking the time to join me on this critical discussion regarding issues that are so important to the work that we do and to all the parties involved in each and every case that we are assigned to as qualified medical evaluators. So I look forward to being with you on our very next session as we bring this program to a conclusion. And for now, I'm wishing you best success in your career as a qualified medical evaluator.